All right, so welcome on behalf of the New York Technology Council. We're pleased to have you for this session, The New Patent Law, What Should Management Be Doing Now? My name is Paul Ellis. I'm a board member of the organization. I run the legal track, and when I'm not doing NITEC events, I run a 5-person law firm, the Paul Ellis Law Group, that represents small to mid-sized technology companies in issues including formation, financing, intellectual property protection, general operations, and mergers and acquisitions. I'd like to thank our sponsors. We're off to a new year, 2012. So we welcome our returning sponsors, Eisner-Amper, Google, TGP, Verizon, and Information Builders. We're also happy to have 2 new sponsors this year, IBM, which is represented by one of our speakers this evening, as well as the law firm of Frankfurt Kernick. So thanks to all of them. So tonight, the new patent law. What should management be doing now? This is a really important topic, one that I've had in mind for doing for some time now since the new law went into effect. I think I'm a corporate lawyer, not a patent lawyer, but I sit down often with early stage technology companies, and this is one of the first issues that comes up, patent protection. And as our panel is going to discuss this evening, the world has changed. Because in the past, they would have the attitude, well, I have a 1-year grace period, I've got time to think about it, it's not a really pressing issue right now. But the focus has shifted, and it's shifted in a way that management becomes much more at the center of determining what the patent strategy is, because you no longer have the benefit of that grace period. And that's just one of the important topics we'll be talking about tonight. Moderating our panel this evening is Ted Sabety. Ted is a principal at Sabety & Associates.
Thank you, Paul. Thank you. First question I have is, how many lawyers are in the audience and how many are not lawyers?
Always got to look for ringers.
Oh, a number of lawyers. Okay. Well, let me introduce our panelists who are very kind enough to join us. On my left is Manny Schecter, who's the Chief Patent Counsel at IBM. He's been at IBM for over 20 years and basically manages and runs the IBM patent portfolio and around the world, mind you. So that's a substantial project, which he tells me is a team of 200 lawyers that have to manage that entire portfolio. He's a member of the American Intellectual Property Law Association. He's successfully piloted projects with the USPTO in terms of new kinds of patent prosecution processes and how to get how to manage that whole process on the government side. He's a graduate of Cornell University and George Washington University Law School, and we're very lucky to have Manny join us for comments from his perspective. And to his left is Peter Schechter, partner at Edwards, Wildman and Palmer. And I've known Peter for many years, and we're very lucky to have Peter as an extraordinarily experienced intellectual property litigator and counselor. He holds a law degree from Boston College Law School and is a graduate from Massachusetts Institute of Technology, and I think it's in marine engineering, right? Which is he has an interest in both. So he does a lot of work with international work, as well as with many companies in the United States in the area of not only in the prosecution issues and the litigation that occurs surrounding prosecution, but also in infringement as well. So we're very lucky to have both of our panelists. So let me spin through and give some context before we get into the discussion. So tonight, the idea of tonight is not so much, the idea I had was not so much to make this, teaching lawyers about the intricacies of the new Patent Act, because that would be a very long program and also potentially dull before dinner. But it's a very interesting topic. But the idea is to get people who are in business, on the business side, to start just getting enough of a flavor of what's going on so they have an idea of when to ask the right questions. And I think that's an important function of what we're going to attempt to do tonight. And right now I'm going to attempt to get the page to go. There we go. So the American Invents Act fundamentally has changed the U.S. patent statute. It was signed into law in September last year by President Obama. And it has, the various parts of it have staged effective dates. which we won't get into all the detail right now. And there are business strategic implications for technology companies that have to be thought about in terms of how one might be changing the way you look at the question of building an IP portfolio or position for your company. So tonight, the 4 areas that I would like to focus on, but of course, if other topics come up, totally welcome, because to the extent we get into that, that's great. The most important thing, the first person to file the patent application has the priority over anybody else is the general rule, and there'll be a little bit of discussion about that. There's a question of the dynamic between whether you want to maintain a trade secret or do the whole patent process. There is also new questions, very important I think for the community in New York, software people in New York, where some inventions are now considered ineligible, especially related to the financial industry. And the other topic that's interesting is that it's now opened up more possibilities for third-party involvement in the prosecution process, meaning you file for your patent and then your competitor decides to submit things to the examiner saying, I don't think this patent should issue. So the first inventor to file, and before I get started, so based on those 4 topics, should we do question and answer after a quick introduction of each topic, or do it all at the end? Who wants to do it as we go?
As we go.
How many want to do it at the end? Oh, sorry, as we go wins. Okay, so the first topic tonight will be, so I'm going to go through 2 slides, and then we're going to start some questions and discussion. So the first inventor to file thing you've heard about, the first inventor to file a patent application on an invention gets the patent over the earlier inventor who files later, is sort of the general rule. And I will get into some discussion, there's some nuance to that. So one view is that getting a filing date has become even more critical than it has been before. And that becomes effective March 16th, 2013. And the reason why we're doing the program this early is you have to plan ahead for this. It also means that things that are called prior art, and that's stuff that tells the patent office that your patent application should be denied because the stuff is already out in the art, is now measured as of the filing date, not what they used to have, which was a year earlier. And it expands the prior art to generally everything from around the world. What I want to talk to, we'll get into a couple of questions on this, is what Paul had mentioned, the 1-year grace period. They do say in the statute that an inventor has a 1-year grace period where they can file a year after they've made disclosures. If they've made the disclosures describing their invention, they have a year. But there is an open legal question of whether the word disclosures includes things like public use or putting it on sale to customers. And there's some debate over that. And so with that, what I'd like to do is bear with me for a second, is I would like to ask a couple of questions. And one is I would like to ask, from an IP management standpoint, given that the grace period has sort of been confined to this, how do you think company management practices in terms of interacting with engineering and finding the inventions and getting the disclosures filed, how do you think those are going to change, or are there any recommendations you can make, Manny?
The first thing I would say is, from my perspective, it doesn't change a lot at all. Make no mistake about it, the change in the law in the American Invents Act is the most significant change in patent law in the lifetimes of basically everybody in this room. But from the perspective of the day-to-day practice, for me and my organization, it won't change very much. We've always been sensitive. You can't hear very well? Sorry. We've always been sensitive to the need to get an early filing date. It's true that under the Act, the need for an early filing date has grown a bit. But it's not as if the filing date was irrelevant before. The filing date was critical even before. You always worried about somebody creating prior art that preceded you. So from my perspective, my organization has always attempted to get our patent applications filed as quickly as we could. So yeah, there's a little more at stake now. But there's still a grace period. There's some uncertainty to it, and I think Ted's probably going to get at that in a few minutes, and we'll probably all decide that we don't really know what it means. But there's still grace periods for your own activities. So the same, for many of your activities, the same 1-year grace period that you had before, you still have. Another way to look at this is before this change in the law, under the current law, which we call first to invent. Under the current law, the party that files first for a patent application can nevertheless lose the patent to somebody that files later in a procedure that's called an interference, in which the patent office basically looks at the evidence that both inventors bring forward to determine who actually made the invention first. Not who filed first, but who made the invention first. But if you look at the statistics from that model, the patent office gets about 500,000 patent applications in a year. Out of that 500,000, they open maybe 50 interferences. And out of those 50 interferences, most of them are actually won by the party that filed first, anyway. So while there's no doubt there's going to be some education that's going to be required of inventors in order to adjust to some of the subtleties here, the truth of the matter is, in a sort of a statistical sense, the risk hasn't changed anywhere near as much, in my view, Peter may tell you differently, as the amount of change in the law has changed.
Well, with that, let's turn over to Peter. So, Peter, you might have a different perspective, because I know IBM has they're, as I understand it, a large company with a large budget to prosecute patents. So, I'm wondering, is there a different perspective for companies that swallow hard every time they have to call up the patent prosecutor and bring him in to file on it?
I know Manny's company's very carefully, picks and chooses what it files on. It does have economies of scale and a larger budget, but they don't file willy-nilly either. I think there's a difference in a global company with a global business and a company that is traditionally and has traditionally been a local business, and local meaning the United States, and the rest of the world, you have to realize, has always had this first to file system. So if you've done business overseas regularly, you've already been sensitive to all of this. In fact, you've been operating under that system even though it wasn't required in the United States, because you would forfeit your patent rights in every other country in the world except the United States by doing all these things. So for those companies, it's not as big a change in the way they do things. But for companies that have traditionally been, for better or worse, more locally focused, they've had a different attitude, I think, about it. And this notion that, we'll see how things go and then we'll file, I think that will change, and it really needs to change. And the way it will change is in a revision, if you will, of the internal management practice of collecting information, documenting information from the creative talent in the company, winnowing through that information, making selections as to what will be filed on and what will not be filed on. And the way it's going to change is that it will accelerate that stuff. So there's going to have to be more decision making with less information. And that will increase costs in certain respects, because companies will file more patent applications, at least at the outset, on things that, maybe they decide a year later it's not going anywhere. So they'll have filing fees, they'll have preparation fees, which can be expensive. A significant chunk of the investment is the preparation and filing of those applications and then filing fees. And then they may be abandoning them. because it's just not worth it. There's no commercial value to it. That's one aspect of it. The other aspect of it is as I said, collecting and sort of documenting this information. There is a new part of the law that we'll talk about called prior user rights, which is the most important thing for me when I deal with small companies who have been accused of infringement of a patent. The first response, I guarantee you, I get from every single client is, "Oh, we already did that. We've been doing that already." Well, in most cases, if they were doing it, they were doing it secretly, and it doesn't really help them very much. If they were doing it secretly now, they have a defense. It's a personal defense. It doesn't really affect the validity of the patent. It doesn't mean that the owner of the patent can't go after other people, but it means if you were actually doing this thing before the filing date is important, you have a personal defense against that infringement. Now, it doesn't mean you're not going to have litigation and it's not going to be expensive and all that stuff, but documenting that stuff for a defensive prior use defense is also a change for small companies. So there are lots of aspects of what we call, the patent management or the patent strategy or the IP documentation policy or patent policy of a company, which we're asked to draft for small companies and medium companies, and sometimes occasionally a large company will come and say, "We never had one." And we always scratch our heads and say, how could that be possible? But it happens all the time. And there's going to be subtle but important changes in how those company policies are written and then how they have to be administered by the management. So I think it does actually, it's not so much that it changes risk, although if you screw these things up, obviously there's consequences. It changes the way they have to approach some of these problems.
So you perceive there's going to be an increased sort of documentation requirement, policing documentation among smaller companies have to start getting into that game and be less ad hoc about it. Are there any documentation changes you think in the IBM case, or in your case it's already so well organized?
Can I engage in a little bit of discussion with Peter about this?
Absolutely.
So there's two areas of documentation that you just touched on, one more explicitly than the other. And maybe if I ask about it, your advice will help this group.
Oh.
So the first one is that patent attorneys for years, this is the one that you didn't address directly. Patent attorneys for years, because we were in a first to invent system where your activities, the dates of your activities prior to filing the application might later be useful in helping you secure a patent in an interference, for example, or in some other nuances that maybe would be a little bit too deep for the moment. Because of that, patent attorneys have long kind of advised inventors to keep workbooks and document your technical progress, right, as you develop things. Do you still advise people to keep technical notebooks for that same purpose? Or do you think that they could go away because there's no such thing as an interference anymore?
That's an interesting question. I don't think anyone has actually put it quite that way. I think there is certainly a reduced need for invention documentation when, first of all, you can't use that documentation in an interference. It's not evidence of any of those activities that invoke this limited form of a grace period. The grace period is called, we're starting to call it the first to publish, FTP, the FTP first to publish grace period, and whether it, and the question, as Ted mentioned, whether that includes offers to sell and sell. The statute doesn't say that, but we're all pretty sure it was a mistake. We're all pretty sure it was an oversight, and it was supposed to say that. I just have to point out, this process has been 10 years in the making, and this thing has lived, and died in every congressional session for the past decade. And the only reason that it got off the ground this time, and then actually happened fairly quickly when it did, at the end stage, was because Manny's predecessor had the ear of the president, and the president actually lent some political muscle to getting it done, and it got done. But at the end, it got done in a way that there were lots of open questions. There were lots of little details. Like after it got passed, we all said, wait a second, now we have to read it. And when you read it, there were inconsistencies and things that seemed to not make sense. And there's already patchwork, patch-up legislation in the works to fix some of these things. But so that kind of evidence that we had before of invention, what will it be used for going forwards? You can't use it. No one cares about your date of invention.
Well, the prior user defense, which we'll get to in the next topic.
Right. But the prior user defense isn't typically found in an inventor's notebook. It's, what is that going to mean? We don't know.
Well, actually, we'll get to that in a second.
We don't know what
There's a
prior
question on the
use
floor.
means right now.
Well,
sorry, go ahead.
Let me just say one thing. So I personally believe it's still useful. It isn't useful for the same thing.
Right.
But let me give an example. Right, this woman and this gentleman are in joint development. She wants to prove she invented it and he didn't, or that they did it together. I mean, there are issues that are going to come up to inventorship and other areas where it could be useful, even though it won't be used for the same the same purpose that people think of first when they think of first to invent.
And I just want to pop in on this. I think Manny struck an interesting point, which is an area of documentation that I find, at least in my practice, it's important for any of you that are getting like SBIR or other federal funds that make your technical inventions subject to what they call the Bayh-Dole Act, and you end up with a subject invention if it was funded. A lot of times companies have mixtures of funding. They have a specific contract to do one particular technical development, but they might have private funding that they're using for something else, and it's important to document that the particular time that engineer was working at his lab bench when he invented this thing, that wasn't being billed to the federal government. That actually would be very critical to be able to demonstrate that, because if you have a separate contracting and activities, you can separate out what was privately funded from what was federally funded, because that has some implications which we're not going to get into here, but are important.
There was a question.
I'm sorry, there was a question, yes.
I'm making this up, but what about the derivation question you mentioned earlier? It's even in my lab notebook might help show I didn't derive it from someone else, I did it myself.
Right. Well, the derivation is going to have lots of proof, and there's lots of aspects of the patent law that do require proof of inventorship that have not been changed at all. So, I mean, it's true. This information still has to be collected. Whether it will be used in the same way, well, it probably won't be used in the same way.
I would have said it's probably a little less likely to be used.
Yeah.
But the less likely doesn't go to zero.
Right.
So, people like us are still going to advise you to document what you can.
So yes, one more question?
Yes, I'm an inventor, and we generally use provisional patents to cover whenever we make something we think we might want to pursue it, and it gives us like a year to go with it. That's still valid?
As far as I know, nothing's changed.
Nothing has changed in this act with respect to provisional applications. Some people have actually speculated that provisional applications use might actually increase as a way to get your invention into the patent office faster, to get your date faster. I've always thought that's got a bit of a risk. There are cases which say if you don't have a complete description of the invention in that provisional application, you won't get the date. And so it's okay to file it. There are some strategic reasons to go that route at times. But for people who rely on it simply for the speed, because of the race that Ted was setting up earlier, they risk the fact that along the way in their race they get sloppy and they don't put enough into that application, and then they win the race and they lose the war. Draw whatever analogy you want.
Yeah, I get phone calls all the time where people go, well, can I just file the provisional? Like somehow it's going to be cheaper to ask me to file the provisional. The provisional still has to meet the disclosure requirements. So the only thing you're really saving cost-wise are filing fees and some formalities, and sometimes in the drawings and things like that. but it's not an extraordinary saving with regard to meeting the necessary disclosure requirements of the filing date can stick. But I think one topic I want to go back to make sure everybody's clear, because in my mind this is probably really important, because the traditional internet company, at least that I've seen in the electronic media area, they roll out their product as soon as it's done. It goes live on the internet, and then they call me up and say, by the way, we have this new whiz-bang thing. We just, one day we've already had 500,000 users. Maybe we should be filing a patent on this whole process. And then because it isn't a year yet, maybe it's only 3 months, you can do something. Now, the problem here is, in the new patent statute with the first to file, they said that, well, if you've made a disclosure, if the inventor made a disclosure, right, that you still have a year. So and I think that the realities here, the universities were on top of this with their lobbyists. So they were thinking, okay, if the professor publishes his physics or material science paper, that the university has a year to file the application. And the reality is that in the marketplace, I don't see many people publishing articles. They're going out and they're putting their thing up on the web and launching the business. And the problem is the word disclosure doesn't necessarily mean public use or putting it on sale. And so the reason why this slide, I want to drill this home, is our current Supreme Court is very what they call textualist. And I don't mean to dive into law, but this is as deep as I'll go for me. That is, if the statute doesn't say it, it ain't so. All right, and that's Anton Scalia and his bill. So textualists will say it doesn't say public use, doesn't say sales as disclosure. So you put it on sale before you file, the patent's dead. The House report on the legislation doesn't even talk about it. And the only thing that I've found is a reference by Orrin Hatch, who cryptically said that anything that would be triggered the prior art provisions were listed public use, on sale, and disclosure would apply here. So sort of implying that he thought this included public use. My view is, and I guess as a last question on this topic, Peter, do you have a view on how would you advise a client in terms of when they should make their product announcement versus when should they roll a product out to the trade show before they and relative to their filing dates?
Well, the only truly safe advice is to pretend there's no grace period. I mean, you have to pretend we live in Europe, basically. There's no grace period in Europe, and as I said, if you've been doing business there, you understand that. You would never roll out a product, you would never roll out a display at a trade show prior to having your application on file. And the U.S. companies are going to get used to that. It's going to be a fairly rude and rough awakening in the early parts when companies make those mistakes. But I'm hoping that this legislation that is being addressed to fix this can actually happen before the law takes effect. And we do have a bit of time. As Ted said, these are staged implementations. So this whole first to invent stuff hasn't gone into effect yet. We still have some time to fix it before that, or at least clarify that aspect before it does.
Manny, I saw you shake your head.
I'm deeply skeptical that it'll get clarified before.
Yeah.
That would be great. I'm with you.
It would be great.
Certainty is always good for us. I just don't see it happening.
Yeah.
I would say a couple of other things, though. I mean, first of all, he's right that for a company like mine, who's been dealing with the lack of grace periods in most other countries, this doesn't affect me all that much. I've always been in this mode. I always prefer my inventors to behave the way he's now advising you to behave. But with respect to something I thought you said before, Ted, I thought I heard you say that you talk about the scenario where an academic puts their paper up on the web, almost as if you weren't sure if that would be considered a disclosure.
Oh no! I'm assuming again until the courts weigh in. I might stand corrected. I mean, I'm reading this as anybody like I read disclosure to mean like an article, and I think they actually talked about it in the House report, that it's like the scientist writes an article on whatever his new material
Yeah, they talk about publication
device
a lot.
is as a publication, and then the university has a year to file on it. And there was some discussion about that. At least that's my view. Do you have a different interpretation?
No, I think if a professor puts his paper up on the web, that will be considered a disclosure, and he'll have a grace period.
Right, that's what I
Yes,
mean.
yes.
But I'm saying that that's a separate thing from what, I mean, there's a lot of small companies or technology companies, they don't publish papers. They go out in the marketplace. That's the publishing.
Yeah, I agree.
And I think that that's the issue that now the companies have to get around, is that the grace period doesn't apply to people who just go into business. So let's move on. Is there any question here?
So I partner with universities. So if I partner and we have, let's say, FDA as a collaborator in some research, they will collaborate. So do we have a 1-year grace period if we're publishing with a university faculty member?
That's a very good question, and I hesitate to tackle the definitive answer right now, but there are two things.
Can you repeat the question?
The question was, if we are collaborating with a federal agency, and you said the FDA, for example, and a university, presumably with federal funding, right? The federal
Not
no?
necessarily.
Okay.
We may have a-
And if the professor publishes, does
Yes.
it apply?
But they may be our principal investigator.
Who's the creator?
From reading the statute, the raw reading the statute, I would say if the professor is the inventor, then it's his disclosure.
Specifically with joint inventors.
If it's co-invented, I'd have to think about that.
We were
So,
just
go ahead. Maybe Manny.
we were thinking that the CREATE Act actually protects you as joint inventors. We were thinking that under the CREATE Act, one co-inventor's activities don't serve to trigger prior art against the other co-inventor.
Oh, that's a very good question.
But your question is very perceptive.
Yes, and I don't have a definitive answer off the fly. Peter, do you have?
Yeah, I mean that's what I was thinking. I mean the thing is, the Act carves out of the definition of prior art, if you will, the work of one co-inventor against another. So those can't be used. But how those actually work, if one publishes, does that grace period apply to all of the inventors? I would guess, and this is a pure guess, and we're not going to know the answer to this, with a decided legal case for years, literally years.
So it makes more sense to file.
It does. That's an easy answer. It always makes more sense to file under this regime.
In every scenario, no matter what it is, a patent attorney is always going to tell you it makes more sense to file early than late.
Right.
Always.
It's
but
just
another part of the answer to your question is, once again, if you're at all interested in rights outside of the United States, the CREATE Act only helps you here.
Right.
It's not going to, if you want to go get rights in China or Japan or Europe, you still need to file early. You still need to deal with the fact that co-inventors' acts may trigger a bar outside of the United States.
And with that, I would like to move on to the next topic.
I have a question.
Yes?
Actually, in some countries, aren't there statutes that enable you to say that this person disclosed it without proper authorization, and then basically get a fix for that?
I don't know what that means without proper authorization. So the question was.
The question was: aren't there countries that if somebody discloses without permission, discloses your invention without your permission, that's sort of exempt from the disclosure rule? I have heard of that, but I can't give you a specific. I don't know if you have a.
Well, you have to distinguish two situations, right? In some cases, third parties disclose your invention because they independently made it.
Right.
In that case, too bad.
Yeah.
They didn't derive it from you, right? So there's no argument that they did anything wrong. In the case that they derived it from you, even under the U.S. statute that's created, you have relief from them, right? If they derive it from you and file before you, That's the derivation proceeding that you would get into. And yes, some other countries do have that.
Well, let's move on because we have 3 more topics, and I'm glad to see we were able to cover one topic. What I want to...
I'm glad we covered that.
I mean, when I was doing the slides, there's so many topics in this new patent statute, I was like, we have to get this down to like 4 basic topics to talk about. The next thing I want to talk about is the balance between trade secrets and patents and how the statute may have changed the balance in terms of your strategic thinking. Now, the basic idea of a patent is the government will grant you a limited monopoly over your invention, your process, your device, what have you, so long as you make a complete disclosure, a sufficiently complete disclosure to teach people about your invention. So to the extent your special device or process is an important trade secret, you now have a decision to make whenever you decide, well, am I going to maintain my trade secret as a trade secret like the formula for Coca-Cola, or do I want to file a patent on it so that I know no matter what I've got this monopoly? So in the one case, you have disclosure to the public with the, through your patent filing, with the risk of either the patent not issuing or the patent being found invalid down the road, versus the risk of maintaining a trade secret where your competitors are free to reverse engineer what you have and figure out what the trade secret is, or even independently figure it out without reverse engineering it for that matter. And so that's always been the case in the patent law, and that's an always important discussion you always have to have with your IP attorney before you decide to file the patent. And there are various reasons that if some things are so easily reverse engineered, you might as well file a patent on it because it's, there's a number of balancing issues. But that tension exists. So in the new statute, and Peter had mentioned this, they have this thing called the prior user defense. And that was supposed to address the problem where you would have people who would maintain a trade secret, and then somehow another inventor would invent the same thing and file a patent on and turn around and sue what actually was the original or the first inventor who happened to decide, I'm not going to file a patent, I'll just maintain the trade secret. So this person's going, I got to pay royalties now to these people, even though I was doing this 3 years earlier. So the prior user, generally speaking, refers to the trade secret user who's decided not to file a patent. And the idea is the prior user can't be liable to the patent owner under the new system if the first filer, the person who obtained the patent, obtains the patent over the same invention and asserts it against the prior user. Now there are caveats. One is the prior user has to have been using the invention for over a year prior to this filing date of this patent that's being asserted against them. It has to be ongoing bona fide use in the United States, and that was put in there to promote jobs in the US. It's what they call personal to the entity that's practicing it. In other words, it's not a right that can be sold to anybody else. And it doesn't apply, and this is really interesting, going back to your question, because if you do work with the federally funded inventions, it doesn't apply to university patents or federally funded inventions that get patented. So if the patent that's being asserted against the prior user is an invention that was created using federal funding, that prior user is out of luck. Now, that's a really interesting wrinkle on all this. So with that, and there's one more thing I just want to mention regarding the, whose lobbyist got that? But anyway, I'm sorry, pardon me. The other interesting thing to consider is the other aspect of patenting traditionally was you had a requirement to disclose the best mode of your invention. You couldn't hide the best way of practicing your invention and then obtain a patent, and your patent could be invalidated if you did that. This is now going away, sort of. There's an obligation to disclose the best mode, but this is something that's already in effect, that there's now no basis to invalidate a patent under litigation for failure of the inventor to disclose the best mode, which obviously raises the question is there anything left of best mode? And so with that, I guess I'm going to start with that and ask Peter, is there anything left of best mode?
No, there never was. And clients hate this, absolutely hate it, because, as Ted says, it's giving away the secret sauce. I mean, the client said, I don't want to disclose this in my patent application, and we would have very difficult very difficult counseling discussions with the clients about that. And now there's still an obligation. The patent law still says you have to disclose the best mode in the patent application. In theory, the examiners in the patent office can't examine that. They have no idea what other modes are. They don't look through this and think, well, is there a different, does the client or does the applicant have a better, different way of doing this? So in essence, it's almost like the honor system. You put it in there, but it used to be the honor system, and it's still the honor system. There used to be penalties. Now it's the honor system, and there's no penalties. So, you know, an honor system that has no penalties, in my mind, doesn't really exist.
So let me jump in. Go ahead, Manny.
I have several things I'd like to say about it. First of all, for me personally, I didn't like the change to best mode in the sense that it's antagonistic to the notion that we as patent attorneys learn that the quid pro quo for getting a patent is teaching others how to use your invention.
That's true. That's a philosophical
But Peter is
difference.
right that patent examiners can't examine for it. They never have. Most patent attorneys you talk to never ever get a best mode rejection in patent prosecution from the patent examiner in Washington.
How would I ever have gotten
The reason why it was removed in litigation was really a couplefold. One was no one else has this requirement but the United States, so there's a harmonization aspect to it. Another one was it was an attempt to reduce the cost of litigation, to take one thing out of litigation pleadings that a defendant could charge a plaintiff with, namely that your patent's really invalid and I should get off the hook. That makes sense, except that since best mode as a defense really was hardly ever exercised, even in litigation. It might have been pled, but a court has, you can count the cases on one hand where courts have actually held a patent invalid. I wonder exactly how much savings we're going to get in litigation here. It's kind of a sleeves off your vest kind of a thing. Maybe the most significant thing here is Peter mentioned before my former boss. My former boss is actually now the Undersecretary of Commerce. He runs the patent office in Washington. And Dave has gotten up in public and said, basically, this is dead. Because his view is, if Congress doesn't think it's important enough to enable it to be part of the litigation process, then as he said, I'm not going to have my examiners worry about it during examination, which they really weren't anyway. Right. But he's basically what Dave was saying is it's still in the books, but it's dead.
Well, let me ask you. Let's turn back from the best
I'll
mode.
just say, in my entire career, I've never seen a best mode rejection in the patent office. Never.
But I wanted to cycle back a little bit and get back to the prior user defense and talk about how, Peter, would the balance, or Manny, either of you, how would the balance of trade secret versus patenting change? Is there going to be, or do you expect there'll be more retaining the trade secret, or that it's generally going to be end up neutral? Why don't we start with you, Peter?
Well, I was going to ask Manny, would
Manny.
in your group, would you actually counsel the people who are writing the patent applications to be a little more coy on the really, on the real, the heart of the matter, such that you can still get your patent with broad protection, but people reading the patent really can't figure out how to do it? I mean, would you actually counsel people that way? I mean, I don't know if I would, but...
No, I think that would open you up to inequitable conduct.
But no one will ever know.
No one will ever know.
No one will ever know.
But, but we as lawyers, I can't imagine we as lawyers are going to do anything which appears to put our employees' credentials on the line. I just don't see that.
I know, but I'm saying there are ways to get close to that line and still be on the right side of the line. I'm sure there are ways to do that. And I can see people sort of sliding in that direction.
But to go more directly to Ted's question, I personally don't see the prior user defense altering the patent trade secret question all that much. Maybe it's different in your environment, but my view generally is in 99 and 44/100% of the time, sooner or later, the information comes out, and you're almost always safer with the patent. That's not always true. There are exceptions. You mentioned Coke. I mean, I don't know if Coke could have gotten a patent, but you mentioned Coke as something which has been secret for a long time. But by and large, my team's bias is on getting the patents. And I have to say, the prior user defense, as implemented, I like it. I think it's a good thing, but it's actually quite limited. It's limited in even some ways that Ted didn't mention. For example, for you to take advantage of that defense, your use has to be continuous. If you stopped for some reason, you discontinued a product, and then you brought the product back, and that was the only product that was using it, you're out of luck. Your use is limited to the same location. So you move, it's a manufacturing process, you move it from, New York City to Schenectady because it's cheaper to manufacture there, too bad. Out went your prior user rights when you made that move. At least your prior user rights that would date back to the use you made in New York City. So I mean, there's lots of limitations in there. They were clearly inserted by those that were concerned about their patents. Frankly, no one has more patents than me that I'm aware of, and we like this provision. I would have been happy if it had been broader, but it simply wasn't. So we might use the defense someday, but I don't see it altering whether I'm going to file a patent application or elect to go trade secret.
Any questions? Yes, sir?
One question would be, and this is only half baked, but you not disclose the best mode without committing equitable conduct, and then you want to sue somebody for trade secret theft. And the trade secret defense says, I have a good defense. You were guilty of an equitable conduct, an unfair thing, because you withheld and you violated best mode. So oddly, not in the patent suit, but in the trade secret suit, it might somehow come up that the violation of best mode counts against you. This is half baked, so I've got to throw it off. Tell me why I'm wrong.
Wow.
Well,
the likelihood of that happening is so low.
Agreed. I'm just trying to think of something.
Yeah, I mean, we could have a whole nother session here about whether inequitable conduct is still a defense. I mean, it's in the statute and we're talking about it, but
maybe that again, the wrong word.
No. But
the reason you kept a secret is so you could bring a trade secret suit.
Yeah, you'd have to have chutzpah. I would put it that way, to intentionally leave that little bit out of your patent and then sue someone for trade secret theft of that secret. Right. It would be a tough situation to imagine somebody actually going through
so that might
doing
be
that.
a reason where it could save the client.
Yeah, I also agree with Manny. It's a limited defense. I mean, it was put in there because a lot of other, again, part of it was harmonization. There are prior user rights defenses in other countries that are much stronger, much tougher, and much broader than this. So it was sort of a nod to, well, we're doing harmonization because now we have a prior user defense, but it really is severely restricted. So I'm not sure we'll see it in practice very much, and I don't really see it affecting that decision whether to file or not. The big trade secret, the big valuable trade secrets that remain as secrets are few and far between. They're largely, I won't say confined, but in my experience, they're confined to large capital-intensive manufacturing processes that involve lots and lots of variables. So it's not necessarily, this one or that one that can be reverse engineered, but it's the combination of all of these parameters of how that process works. That's very hard to reverse engineer without literally walking out of the plant and selling the whole, thing to the Chinese, which apparently isn't that hard anymore. But other than that, that's where.
And of course, the final piece in being able to use it, you mentioned
you got to build
early on. No, I was going to say you mentioned early on. You got to have the proof. Right. So if you're thinking you may ever need this defense, start writing it down. You need to have good documentation.
Right.
You can't just come in and aver, I've been using it for 10 years. That isn't going to do it. You're going to have to produce your manufacturing process documents that are dated appropriately in order to get attributed that defense. And then you're going to have to show, yeah, I've been doing it here, and I've been doing it continuously, and all that other stuff that we talked about. It's not going to be...
And you'd be shocked at how hard it is to recreate the process by which a factory operates, even if it's been operating the same way since the day it started churning out widgets. It turns out that lots of the stuff just never gets written down, and the machine is still running, and still nobody knows how it's running or why. But and there's no documents.
I do on the no documents thing. There is something I do want to point out that's important. I was representing a client that was in fact the first user in a patent case. We weren't going to use the first user defense, but it was in the computer area, so it was a computer process. And the most interesting thing was, because it involved computers, they were unable to demonstrate that they in fact were the first inventor, because they were talking about something that happened 15 years ago, several generations of servers ago. So all the date stamps on the files were not the earliest, because of the way the data gets updated in the file directories. There was no real document showing that here's the executable from 1992. They couldn't say, I can demonstrate that that's the executable version from 1992. So I'm just pointing that out so that for the people in the computer area, I would say it seems that from the panel that this is probably not something you may want to depend on, but you may want to document when you're launching a process that, say, it's server-based, so you're not going to disclose it, that you still may want to burn a disk and have a steady process management-wise where you're dating your disks, and that's the source code, and that's the object code from that year or that set of months or that version, and really keep that. Don't just keep overwriting files, as I know 90% of the software people do as it improves, because the idea is that now you have a documentation you've systematically maintained that you can go back and say, oh, that was the disk from 1992, and that operates the process that you claim you invented first.
Essentially, you need your own private Wayback Machine.
Yeah, and almost nobody does that. I mean, I'll be honest, a lot of people don't do that.
Yeah.
Yes, there's a question?
Every software company
When they get to that, yes. When they get to a certain level, they do. I agree, but I'm saying a lot of times, because of the earlier stage, getting seed funding or first round financing, they're roaring towards getting the product out the door, and they often trip over that. Then they start, once the product's out the door, then they're starting to keep records of their versioning.
That's
but well, that's good. Okay, great.
Question, please?
Yes.
How does IBM and all the big tech firms counter China with their piracy and their counterfeiting, and now that China's manufacturing is moving into the high-tech sector? What does IBM do?
I'm sorry, you spoke very quickly. Could you just slow down and repeat it a little bit?
How does IBM counter China with their piracy and their counterfeiting, now that their manufacturing is moving from widgets to the high-tech? Just heard something amazing that they're selling iPhones in India, I think, for $35.
Okay, well, so the question was about how IBM counters piracy in China, which doesn't directly relate to the
It's not related to what we're doing
topic
tonight, but I don't know if you want to spend.
What?
Is it a patent question? No.
No, piracy generally is more of a trademark and copyright question, where parties copy your logo, put your name on products that you don't produce, or make copies of things like code, music, videos, and the like. And
more
by and large, while we do have a problem with that, we for example have had companies in Asia that have put our names on automobiles and all kinds of things. But actually having our products mass produced, the same products mass produced, we're not in the consumer marketplace anymore since we got out of the PC business. So that tends to be more of a problem for the entertainment industry, the consumer end of the software industry, that kind of thing. Publishers.
Let me. I don't mean to cut you off, Manny, but
No, go ahead.
we have limited time. But I wanted to move on to another topic, the next topic, which I think is also important for especially for a New York audience. There are now statutory rules regarding what kinds of inventions are ineligible. One category is inventions related to tax preparation or tax strategy patents, and there's some caveats with that we can discuss, but generally speaking, if you have a new way of lowering your taxes that no one's thought of before, generally speaking, filing a patent on that's now not going to be possible. If you couple it with the idea of processing that methodology through a computer, that's also likely not going to be eligible for patenting, and that's now stated as a category of subject matter that they're not going to let you patent on. They also have excluded patents encompassing a human organism, which is the wording of that I find intriguing. And I'll let our panel comment on that as well. And then one question that's come up that I've seen in people discussing the American Invents Act as to whether the limitation on business method patents and certain financial processes that banks might conduct, and this is the Chuck Schumer provision. He stuck in the idea because the banks in New York had complained that they didn't like people suing them for how they were processing financial transactions. Whether that now actually has the wording of it sort of expands out, and in some cases really actually calls into question whether many, if not most, computer-related inventions will be ineligible for patent protection. And so with that, I guess I'll ask Manny, is that true that this limitation on business method patents is going to essentially gut the idea of a computer-related invention?
No. Can I talk about all three of these?
Yes.
So with respect to tax prep, the first thing is technically, if you read the act, it doesn't say the inventions are ineligible. It says they're in the prior art, which is the same thing, but for whatever reason, Congress found it more palatable to say it differently. But it doesn't. The hard part there is parsing what's allowable from what's not allowable, because there are exceptions for the tax strategy, so long as it doesn't go to something which specifically enables you to reduce or avoid taxes. Congress found that offensive, right? That you could get a patent on that. So, for example, if you write tax software that just helps somebody file their return, although I suppose in a sense it helps them avoid taxes because they figure out their taxes along the way, that actually can still be patented. With respect to the human organism item, that actually has been around for several years. It's just been kind of restated here. With respect to the business methods, you're actually mischaracterizing what's in the law. There is no limitation on business method patents in the America Invents Act. What's changed in the Schumer amendment, or whatever you want to call it, is the fact that it's easier to challenge the validity of a business method patent. This may be your final topic, I forget, but there's some new procedures, expanded procedures for defendants to challenge the validity of patents after they issue, or for third parties to challenge the validity of a patent after it issues. And one of those procedures in general use is limited to the first 9 months after a patent issues. That 9-month window opens up for business methods. So it doesn't limit one's ability to get a business method. It just makes it easier. It offers more grounds for a party later to be able to question whether the examiner got it right. It's still the same prior art. It's still the same criteria which determine whether that business method is in fact eligible for patenting.
So Manny, do you think then, and again, I want to make these easy to read, so I disclaim any accuracy in order to sort of paraphrase what the law was. So the question I have is, from your perspective, do you think these provisions that have been sort of put in here are going to raise issues with computer-related inventions that you do see that at least to date, have considered to have some merit, like ways of organizing and storing data, ways of processing the data and setting up systems and things of that nature? No, because the
definitions of statutory subject matter, of patentable subject matter hasn't changed. The standards for obviousness hasn't changed. The thing that will happen here is we'll get some patents that will get challenged that the challenges may happen sooner. I'm not personally convinced that the challenge procedure will get, I'm not sure how often it'll get used. But if it gets used with any reasonable rate, what we might see is issues come to a head more quickly. In other words, parties may not have to wait till litigation to bring the challenge or to move the patent. But even then, that's a decision that's made in the patent office. It's not a decision made in court. So the patent office could decide a particular issue in a particular way based on a post-grant review kind of challenge. It doesn't mean that a court will agree, right? So while it may have an effect on that specific patent, the principle that the court might apply doesn't necessarily change one bit just because the patent office takes a different interpretation of the law.
Well, hang on. How about the reverse situation? And we've seen, and this is now we're diving into some law, that since Bilski and some of the cases that have happened this year regarding computer-related inventions, isn't there sort of a trend at the Federal Circuit that makes it sort of questioning the computer-related inventions, so that in combination with this, you really,
Well, so you're talking about CyberSource, the CyberSource case, and some others. I'm not sure that I'd say it's a trend. What we see, I think, is disagreement amongst the different panels on the Federal Circuit. The Federal Circuit is the court beneath the Supreme Court, which hears all appeals of patent trials in the United States. So it's, for 99% of patent law, it's the Supreme Court of Patent Law. And they hear cases in panels of 3. But I forget how many judges actually sit on the CX, 12 or 15, and they don't all agree. I mean, this is hard stuff. If we can't agree, why? I mean, maybe they're smarter than me, but they still don't agree all the time. And so what I think we're seeing right now is they're trying to come to uniformity, and they're struggling amongst themselves. But I don't see any changes in the America Invents Act per se, which alter how they ought to be thinking about it. I only see something which might affect the timing with which issues may arise with them.
Peter, do you have any comments? What's your view on it?
Well, no, I agree. This doesn't really change much. I think we're much more likely, if at all, to see, a real sea change in that area from the Supreme Court, not from the Federal Circuit either. In Bilski, there was a very close vote, actually. There were a group of justices, 4 of them, that wrote stuff that you could infer that in the right case, they might have gotten a 5th vote and issued some kind of crazy blanket prohibition on however they define business method patents, methods of doing business. But that didn't happen. It could happen still, and I think that's what's happening. We're seeing these very rarefied cases go up where you get a fact pattern that so far pushes the envelope that it does make even the people who are sort of in the middle on the question analytically think about it, and perhaps they want to vote in a certain way. The real challenge will be for the Supreme Court to continue to find certain methods of doing business, or certain method patents per se. They're not necessarily doing business, they're just method patents, and to continue finding those as not patentable subject matter, because typically that you can really just sum it all up. They're too abstract. They're just abstractions. They're abstract thought processes that someone has couched in terms of software or a programmed computer or whatever.
Well, hang on. Let me interrupt you on that, because there was that other case. I forget the name. It was the graphics display case, where they really had a particular way of organizing all the video and those calculations, and how they were going to get the hidden the hidden surfaces.
Different and gray values.
Yeah,
and all that
and then
kind
they
of stuff.
called that, oh, well, that's too abstract to file on. And then they had another one that they said it was okay, that was subject matter. And it just seems to go all over the place.
Well,
but,
again, you're talking about the Federal Circuit,
Yeah.
and they are all over the place. I'm talking about the Supreme Court.
Right.
So in the Supreme Court, that's what's going to happen. I mean, the change is not going to come from the Federal Circuit because they are all over the place. The change is going to come, if it comes at all, because there'll be a really extreme case, and a fifth justice is going to say, I'm voting with the other four, and then the struggle for them is going to be to write an opinion that really says that this class of patents is not what the patent system was designed for, yet not to write that so broadly that it wipes out much more than they intend. With this act passed, I think that actually gets taken down one notch in likelihood, because one of the things the Supreme Court considers is, well, Congress has just, talked all about this. They know the controversy that's out there, and they decided to leave it alone.
Well, that's an interesting perspective.
They could have put something in here if they wanted us to, exempt from patent coverage this whole class of inventions, and it's not in there. So you could say, well, Congress has figured out where the line is that they want it to be. It is a statutory system, and the Supreme Court says that's enough. Especially Antonin Scalia can say it's not in there. We're not gonna make it up.
So that's an interesting perspective. So you're saying the fact that this was visited a bit in the statute without prohibiting that as subject matter makes it in some way.
There were very specific problems here.
Right.
There were very specific issues in effect. I mean, you mentioned the banking things. We tried. I mean, we were all hired in the go-go 90s years as private practitioners. We were hired all the time. Go visit Barclays, go visit Morgan Stanley, go visit all of the banks and the investment banks, and they wanted to patent their financial instruments. We have this bond, a new way to calculate return on a bond. For this instrument, we want to sell this thing. We don't want anybody else to be able to sell this investment vehicle. And we would kind of scratch our heads and think about it. And I think as an industry, because we were always being called on to do that, as an industry, that whole effort failed. And once it failed, and the banks and the investment banks and the JP Morgans of the world, as soon as everybody realized that, well, we're not going to be able to really make this work from the patent side, let's kill the whole thing. And that's sort of where that came through. But you can see how long it took. We're talking about, another 10, 12 years before that really came to fruition.
Well, great. And with that, let's move to our, thank you. And with that, let's move to our next topic. I wanted to talk about third-party involvement. Now, when you go to the patent office and you file your patent, in the traditional world, it's the examiner looks at it, typically has problems with it, doesn't like how your claims are drafted, what have you, and sends you an office action, or your lawyer drafts a response, arguments, amends the claims, satisfy the examiner, sends it back, and this goes back and forth. And traditionally, a third party, one of your competitors, who might, when the patent application publishes, see that you have this application pending, the statute had this odd notion that they could submit art, but they couldn't once it published. So obviously, how would they know you'd filed a patent? And once they knew about the patent, they couldn't submit third party, their own art, to suggest to the examiner that here's some prior art. Now, I've been on both sides of this issue in my practice, but now it's set up where a third party can actually submit art to the examiner. So that means if your competitor is filing a patent application you think they don't deserve because it's, you have an article that was published 10 years ago on the same process, you can send that to the examiner for it to be considered. The other thing is, as Manny mentioned, there are these additional, what they call post-grant review proceedings, where after the patent issues, there can be instituted, based on certain conditions, a review of the patent that has already gone through the examination process. And so the question I have for Peter is, do you expect to be advising clients to really be far more proactive in examining what their competitors are up to and making these submissions, or are you attracting attention then and potentially getting targeted? Or
This is actually going to be a significant change in, I think, not only what we do for our clients, but how clients have to monitor what's going on in the patent office. Because there is a 9-month window on post-grant review, that's not to say there aren't other procedures. So today we have two things. We have ex parte, which means we have ex parte re-examination, which means only the patent owner participates, and we have inter partes, between the parties re-examination, where the third party requester is in an adversarial position to the patent owner, but has very limited rights. And I handle lots of those, and it's good in certain cases. It's not great in most cases. And for years, it was not great at all. It took years and years before any of these things were really filed. And there's still not lots of them. But now that's being replaced by 3 mechanisms. The ex parte re-examination will stay, actually 4. The ex parte re-examination will stay in place, essentially. There's another thing which is just defensive, purely but only for the patent owner, called supplemental examination, where the patent owner can go to the patent office and actually cure defects in the patent that otherwise might result in really bad things. And we don't have to go into the details, but that has been thrown in there. That's like really throwing a bone to the patent owners in this case. Now we have 2 different things. We have inter partes review, which is different from inter partes re-examination, and we have post-grant review. And this post-grant review is a limited window, 9-month period. You can raise any defense you want. It's not limited to the traditional patents and printed publications of inter partes re-examination. The inter partes review you can do after the 9-month window or after a post-grant review has been terminated. That's the other big change. You can file a post-grant review and the 2 sides can go at it, and there's discovery, limited discovery. It's not litigation, U.S. federal court type discovery. There is some limited discovery. We have no idea how that's going to work, frankly, none. Whether they're going to have administrative law judges, how the patent office is going to administer discovery disputes, a mystery. It's just a blank slate at this point. But the parties can settle that thing, and that has never been possible. It was always a, pull the trigger and the bullet is flying and nobody can catch it in re-examination proceedings. So it was sort of a one-shot gun, and there was nothing you could do to stop it. Now you can settle it, and that throws a whole strategic layer onto this post-grant examination and challenge.
What's the settlement? What would the settlement entail? I mean, I'm
the parties can settle. They can.
Do I get a license out of it?
Who knows? They can settle on any terms they want, but they can settle, and the post-grant review will be terminated. So it ends without a decision, without a determination. There are what are called estoppel provisions, which say that the party who filed this thing cannot later in litigation raise any defense that they did raise in the post-grant review or could have raised in the post-grant review. That's pretty brutal.
Well, hasn't that been the disincentive to do it?
That's always been the disincentive to do.
There's one other key disincentive, and you mentioned it in the beginning. The estoppel is certainly one, but the other one is you as a challenger, this exists today in the existing inter partes re-exam, and it stays in inter partes review and post-grant review, and that is you have to reveal yourself. You have to identify the real party in interest. So if you file one of these things, query, why would you do that unless you're concerned that you may infringe the patent? So if you're the patentee and somebody has to reveal themselves to you to challenge the patent and they lose, you're going to be watching their products very carefully because you suspect that they either now or are about to infringe. So you're painting the bullseye on your head as a challenger.
Right.
That is a risk you must weigh extremely carefully.
The only time I have ever actually recommended inter partes reexamination where we have to reveal who we are situations where the client saw an opportunity in a market that they were not already in. And they thought, if we can knock out this patent, then we can move in there. And in that situation, it works. That's pretty rare. It's pretty rare.
There's a question.
Any questions on the floor? Yes.
But isn't it often the case that somebody brings a re-exam request because they're being sued?
Yes, and there are changes to that as well. There are changes going to be.
I mean, as opposed to an invalidity counterclaim.
Okay, so the way this works, I have to actually look at my crib notes for this. If you file a declaratory judgment action for invalidity, let's say you get a nastygram from patent owner X, and you go to federal court and you file a declaratory judgment for invalidity of that patent. Today you can game the system. You can file that case, then you can go file your inter partes re-exam, and then you can tell the court, stop the case, let's put it on the back burner for the 6 years it takes us to get through the patent office. And there are other strategies you can do there as well. If you now file a declaratory judgment for invalidity and then go to file your petition for either inter partes review or post-grant review, that petition will be denied by the patent office. Once you choose to go to federal court and file a declaratory judgment action, that is where you will be. And that includes counterclaims for infringement.
I think there's also a trick in the reverse order
Yes,
as well.
there is.
If you file the challenge in the patent office first and then file the legal challenge in court, the court case will get stayed,
Right.
waiting for the patent office to finish up the re-exam or the post-grant
Right,
review.
right.
So basically what they're trying to do is force you to pick one or the other so that you can't continually keep the patentee on the defensive. You can't sort of harass the patentee with constant challenge.
Right. And
Sooner or
that's-
later, you got to get done.
That's an automatic stay provision that's in the new statute. The other one that, and then there's a third way this works. Let's say that you are served with a complaint for infringement. At that point, you do actually have a limited period of time where you can decide what you want to do. So obviously you're already in litigation, so you got to do something with that. But you have a year in which to decide whether to seek inter partes review. If you file within that year, then it's discretionary with the judge whether to stay the litigation or not. You may actually get stuck in a two-track dispute with your sworn enemy. But the court could stay the litigation. That's discretionary. But if you wait more than a year after you were served with the complaint, then the petition for inter partes review will automatically be denied. So they're trying to end that sort of tactical gamesmanship that goes on right now. And in fact, they have ended it. It's once this stuff goes into effect, it's over.
Any other questions on this topic? Okay. Well, I think that was our last topic, because this is just my canned questions, and I would like to thank our panelists, Manny and Peter. I'm sorry, was there a question? Oh, I'm sorry, one last question.
There's some type of, I believe there's a new expedited review for green technologies. No one spoke about that.
For
green?
Green, yes, there's
there
a
are
question of expedited examination of certain kinds of inventions. There are.
Nanotechnology by definition, green is using small.
Well, actually, I have a client that's in nanotechnology, but they have a solar power-related device that's made with nanotechnology, and now that got expedited.
But even if it's a nano drug delivery, you're using smaller amounts.
I don't know if that's green. It might not. Well, that may qualify for other. There are other qualifications that can get you expedited review. But I do know for nanotechnology, even though it's a material, if it has applications in energy savings, of green technology, pollution, they'll give it expedited review.
So it's not just the method of having energy savings; it's the use of it.
Yes.
Has to have energy
There's also a provision in the America Invents Act that enables you to expedite the processing of a patent application without your application technology qualifying in any way whatsoever, so long as you're willing to part with a little green, a different kind of green, namely $4,800. You get acceleration.
That's a different kind of green technology.
But that also reminds me of one other point we didn't just make in the previous discussion, which is there's one other deterrent against post-grant review and inter-party re-exam challenges, which is the cost.
It's unbelievable.
It's cheaper than litigation, but just we don't know what the fees are going to be yet because they haven't fully published them. But they've started to roll out the fees for some related issues, like the supplemental examination, and they're incredibly expensive. $4,000 or $5,000 just to file, and then if the patent office disagrees that that you've met the standard for getting into that process, you just lose the money. If you go into the process, it's another $10,000 or $15,000. To file a post-grant review, the rumor is the fee will be $40,000.
I heard 50.
Right? So it's not going to be trivial. So that clearly is going to act as a brake on the number of challenges that will occur.
Attorneys charge $50,000 just to review the patent and tell you whether the patent's
Maybe he does.
But so add the disbursement of $50,000 on top of that.
I have a question over here.
Yeah, I'm sorry, this goes back
Go
to
ahead.
the first one. All right, as an inventor, I'd be talking to potential distributors, suppliers, so forth. In the past, it was you get an NDA, it's treated as confidential, you preserve your patent rights. Now with first to file, it kind of sounds like the NDA is almost irrelevant because if somebody, forwards your email to somebody else and they file it, you have no recourse.
No, if it turns out that that disclosure, the person who made that public disclosure, derived it from you.
Right. But I mean, how would you ever prove something like that? If somebody forwards an email to somebody else.
Emails forever.
Yeah.
Somebody can forward an email now.
I know, but the thing
and
is,
you still suffer from it.
But still, first to invent.
Well,
you had that fallback. Of
true, but if they did it now, they're going to cost you foreign rights if you happen to go seek foreign rights, right? It still has the same effect. It maybe not quite as broad because, especially if you're a U.S. primary organization, and unfortunately, if that happens to you and you can't do the kinds of things that he just talked about with derivation, you're basically left with a breach of contract argument against the party that violated your confidentiality.
Or a misappropriation case or something.
And you'll never know who did it.
You're in court either way.
You'll never know who did it.
Yeah. It's
now, there is a.
The moral of that story is know who you deal with.
There's a wrinkle on this first to file that I just did want to mention that's the way the priority rule is going to work, just so you know that there is a condition under which the later filer wins the race, and that's if they were the first person to publish, and that later filing was in that year grace period. Did I get that right?
Yeah. Can you bring up? Is it possible to bring this one
That's
up?
the first inventor to publish rule.
If you could bring up this one and go to those 3 slides, we'll just walk through it.
You said you had a thumb drive.
I do.
To bring
I'm going to do that.
We'll keep going.
That's one of the scenarios under which provisional applications people have speculated about using them.
Yeah.
Or there have been people who've talked about possibly publishing in order to put their stake in the ground so that anyone else who comes later and tries to create prior art with their own publications will be effectively preceded by the inventor. But you take risk when you do that. Once again, while that may help you in the U.S., it blows all your foreign rights. So if you're interested in, since the grace periods don't work the same outside the U.S., you're trading one country, you're trading the U.S. for others. And you have to intelligently make that decision.
If you filed the retro here, that would save you that problem. If it was decently professional, not just a piece of.
If it's fully disclosing, it will help you. The word we would use would be enabling.
What?
If it's enabling.
Then it's not really disclosed because it's not gone, it doesn't go anywhere and it's not examined, correct?
Yeah, but it's a filing date.
Yeah.
Does the patent office also have a storage process where you can send something in and they will hold it? It's not provisional, but they have a storage process, or they used to.
I'm not sure what you're referring to. You may be thinking of the statutory invention registration, which was kind of a defensive publication that they did.
You just send it in and they would just hold it until you actually said, I want to use it.
There used to be a disclosure. You used to be able to send.
I'm not familiar with that.
I got one question over there. Looking.
All right.
With best mode, if you don't give the best mode, how can you truly defend against infringement if the infringer comes up with the best mode and you give less than the best mode?
Oh, so I can explain that, I think. Right? When,
Can you repeat the question?
I'm sorry, this will be the last question, and the question was how, if you have the best mode,
If you don't give
the best mode, how does the other side prove you didn't give the best
No,
mode?
no. How
No.
do you defend against infringement when the infringer uses a better mode?
Oh, it depends. Oh, go ahead. Sorry.
well, so I think the point that you may be missing here is that while you didn't disclose the best mode, it doesn't mean you didn't claim the best mode, right? You've all seen claims. Claims are that thing which is like the language in the deed for your house that describe the metes and bounds of the invention, at least in theory. Hang on one second. And just because you don't disclose the best mode doesn't mean you don't write your claims broadly enough to cover that best mode. So you may not have disclosed it, but the other guy could still infringe your claim. Right?
All right, well, with that, I will turn it over. Let's thank our panel once again for that excellent